Thanks for being here, and appreciate your family and friends joining with you on this important day in your lives. Mr. Meredith, you heard my opening statement relative to the pardons that were given by the governor of Kentucky. Why don't we give you an opportunity now to explain the questions that I raised?
Senator, I can tell you that I learned about the governor's last-minute controversial pardons in the media after we left office. And I remember in your opening remarks, you mentioned the Baker pardon, and I can tell you without hesitation that I did not review that pardon file, and I did not advise the governor on that.
How about another individual who received a commuted sentence, Dayton Jones, child predator convicted of sodomizing an unconscious boy and causing life-threatening injuries?
Same answer, Senator. I did not review that file, nor did I advise the governor on that.
Who advised the governor in terms of his pardon policy?
Well, there were several lawyers in the office. I don't know who advised the governor. I don't know if anybody did. You know, perhaps the general counsel did. I would be speculating, Senator. It wasn't me, and I don't know.
Mr. Mercer, there's some question as to, I'm not going to go into the history with the U.S. attorneys. Let someone else raise that if they wish. But I'd like to ask you about your characterization of the January 6th defendants. Did you make a recommendation to the Montana Republican Party to insert a characterization in their platform that the January 6th defendants were being held in indefinite detention?
Hey everyone, welcome back to the channel. If you're new here, I'm your independent political analyst, no spin, no tribalism, just the facts, the law, and thoughtful context. Today, we're reacting to a recent Senate confirmation hearing involving judicial nominees Mr. Meredith and Mr. Mercer, where some very sensitive and controversial topics were raised. Let's break it down with clarity and care.
Ranking Member Durbin, I do not believe so, and I certainly have no recollection of that.
What is your feeling about the prosecution of the January 6th defendants? It's become something of an issue here.
Ranking Member Durbin, my view is that those are cases that were considered by the department and brought and adjudicated in the system, and the outcomes are clear, and I don't have anything really to add on that issue.
What is your reaction to the full and unconditional pardon of the January 6th defendants by President Trump?
Ranking Member Durbin, my position on that is that the pardon power is something that the judiciary has no involvement in, and as a nominee for this position, I don't believe it would be appropriate for me to comment on that issue.
While serving in the Montana State Legislature, you initially opposed a bill designed to eliminate the 3-year statute of limitations for civil lawsuits by sex abuse victims. A group of survivors were critical of you and said that you made a total sellout in favor of child molesters and insurance companies. I'm relieved that despite your opposition, a compromise bill was enacted. If confirmed, how can victims of sexual abuse rely on you to rule on their cases fairly and justly given your opposition to extending the statute of limitations for these types of cases?
Ranking Member Durbin, I respectfully disagree with your construction of the matter. The bill in 2019 was brought to create an unlimited statute of limitations with respect to child sexual abuse hands-on offenders. And we looked at what had occurred nationally in terms of similar statutes with a healthy respect for what statute of limitations bring in civil cases, which is the ability to have measures brought in a timely fashion. We ultimately surveyed nationally what those provisions look like in other states, and we concluded that most states allowed victims of child sexual hands-on offenses to bring those cases sometime after reaching majority, and usually for some period of time after reaching majority. So the statute that we ultimately passed created the ability to bring that case up to, I believe it was age 26. It was either age 26 or 27. That puts Montana code firmly in line with what other states have done. And the key thing in that legislation that we did was create a much more robust reporting mechanism that allows us to have clarity, or rather allows the Attorney General of the state to have clarity through the county attorneys on matters being referred for investigation by the Department of Public Health and Human Services. So we thought it was very important legislation, and we're pleased with the outcome.
Mr. Meredith, beginning in 2017, you defended a Kentucky law that required doctors to present certain information to patients before the performance of an abortion procedure. As part of your defense of that law, you stated, and I quote, "Not every patient understands the consequences of an abortion procedure." You further stated, quote, "There are a number of patients who don't understand the nature of the fetus within them." Mr. Meredith, what was your basis for asserting that female patients do not understand their own medical needs?
Senator, my recollection is that those arguments were rehashing for the court the evidence that was in the record. My recollection is that there were several sworn declarations in the record.
What were the sources? Do you know?
I'm sorry, Senator?
What were the sources of those statements?
Those were declarations from individuals who had received abortions in the past.
Do you believe that female patients are less likely or less able to understand medical advice than male patients?
Senator, I'm sorry, I'm not sure I understand your question. Could you?
Well, you said not every patient understands the consequences, and we certainly know that we're talking primarily of women of childbearing status. And you went on to say there are a number of patients who don't understand the nature of the fetus. Do you believe that female patients are less likely to understand this?
No, Senator, what we were saying in those arguments is we were summarizing the evidence in the record for the court. There were several witnesses who testified by sworn declaration that they wished, my recollection is they said they wished they had that information because they didn't quite understand the nature and the consequences of
Didn't
that
understand
issue.
the nature of the fetus, women?
My recollection is that the testimony in the record in those sworn declarations said that that would have been helpful information that they would have liked to have had. And I believe that also was kind of hearkening back to statements in the Supreme Court's Casey opinion, as well as perhaps Gonzalez v. Carhart.
I'm going to tell you that I don't understand what you're saying based on this quote here. And if you wish, it's your decision. If you want to clarify what you've just said in light of what I quoted, please do so, because at this point I believe there's really a serious question as to what you were trying to say.
Senator, we were just simply making an argument based on the evidence in the record, and it was the
Your
Commonwealth's
decision as to whether you want to clarify it, but at this point I think it's going to be a problem for some of us. Thank you very much.
Senator Welch.
First, Mr. Meredith was pressed on controversial pardons issued by the Kentucky governor, including individuals convicted of violent sexual offenses. Meredith flatly denied having any involvement or knowledge of these cases while in office, saying he learned about them only through the media after leaving government. Now, that kind of distancing is not unusual in these hearings, but it does raise a practical question. How are such high-stakes decisions made without clear internal accountability? If multiple lawyers were involved, as Meredith vaguely alluded to, shouldn't the public, or at least the Senate, know who was responsible? That lack of transparency is troubling regardless of political alignment. Next up was Mr. Mercer, who was asked about his alleged involvement in shaping party rhetoric around the January 6th defendants, specifically whether he recommended calling their treatment indefinite detention. Mercer denied it and claimed no recollection. When asked about the prosecution themselves, he gave a pretty standard response, that the Department of Justice handled those cases through due process, and the outcomes speak for themselves. On the question of pardoning all January 6th defendants, Mercer sidestepped, citing the judiciary's lack of role in the pardon process. Here's where neutrality matters. Mercer was wise not to editorialize on those cases, especially if he's up for a judicial post. But at the same time, these are politically and socially charged cases, and the public deserves more than just legalese. Even a simple acknowledgement of the seriousness of the events of January 6th might have helped establish credibility and trust. Then things got even more complex. Mercer was questioned about his opposition to a Montana bill eliminating the statute of limitations for civil lawsuits brought by survivors of child sexual abuse. He pushed back on the characterization that he sold out victims, saying his final compromise bill was actually in line with national standards, allowing victims to file suits until age 26 or 27. To be fair, this is a difficult legal area. Statutes of limitations exist to preserve the integrity of evidence, but when we're talking about crimes like child abuse, those timelines can clash with the reality of trauma and delayed reporting. Mercer's defense shows he made an effort to align Montana law with other states, but the fact that survivors publicly condemned his role in the process can't be ignored. In a judicial role, public trust matters, especially when it comes to protecting vulnerable populations. Finally, Mr. Meredith faced a grilling over his past offense of a Kentucky law requiring doctors to provide specific information to patients before an abortion. Critics hone in on his court arguments, suggesting that many patients implicitly, women don't understand the nature of the fetus or the consequences of abortion. Meredith tried to clarify, saying he was simply summarizing sworn statements from women who had undergone abortions. But the senators weren't buying it, and honestly, his clarification fell flat. This wasn't just about the legal record. It was about perception. Here's the problem. Framing women as less informed or incapable of understanding their own medical needs, even if based on selected testimonies, can come off as deeply patronizing. Meredith didn't need to say that outright for the message to land that way, and he didn't really clear it up in a hearing. So what's the takeaway? Both Meredith and Mercer kept their answers loyally cautious and noncommittal, but maybe too cautious. In an era when public trust in institutions is low, avoiding transparency doesn't inspire confidence. This isn't about left or right, it's about whether those who sit on the bench have the clarity, fairness, and integrity to rule impartially and communicate effectively with the public they serve. Thanks for watching. Let me know your thoughts in the comments, especially on how judicial nominees should handle politically charged questions during confirmation. And don't forget to like and subscribe if you want more breakdowns like this, without the noise.